why are you here is what I really want to know. What brought you here other than a motor vehicle or Lyft or Uber here, as the case may be? If we could have some volunteers and maybe a little without getting maybe too personal, caring for a loved one, and what topics are you interested in? I'm an elder care law attorney. I am an advocate for seniors and those with disabilities, and to assist their caregivers to get how to be the best possible caregiver, get access to quality care, then figure out how to pay for it without going broke. That's what I do for a living. So with that said, what are your concerns? What are you concerned about? Feel free, go. And your name would be helpful. Bridget.
We have a financial plan, we have our advanced focus, but what I know is Medicaid. How much are you allowed as a spouse if you were to spend down your husband's portion? Would you have to sell your home that you both living together, or are you going to be preoccupied housing for myself?
So, sounds like your husband has some form of Alzheimer's or related dementia. Is that correct?
Yeah.
And you're concerned about, we okay?
Yeah, I was just saying, for the video, if you could repeat the question. You're doing it. Yeah. Sorry.
All right, fooled you.
Sorry.
So, you're concerned about how can, if your husband needs ongoing 24/7 care, possibly nursing home care or related type of services, how can you be protected as the healthy of the two spouses and possibly rely on Medicaid? What assets can you keep? Can you keep the home, a motor vehicle, etc.? That's your concern of yours.
Yes.
Okay. I will touch upon that.
Okay. I mean, you don't have long-term care insurance, but I would be able to care for him quite well at home.
Understood.
But
I will touch upon that. And I may not address your specific situation, but I'll talk in generality, obviously. Now, I can't talk about your specific circumstances. Anyone else? What are your concerns regarding a loved one? Why are you here? Yes, sir.
My name's Richard. One of my concerns is that if something should happen to me, and my wife still needs care, what's the best way to go about protecting assets and putting money in trust or whatever, so that she could be taken care of, because being probably the only sole caretaker, what happens then? Who takes care of her then? And guardianships, and how to be careful about those.
Okay. Richard, you're asking a similar question in a different way, I would argue, that Bridget asked, meaning how to protect assets if my loved one needs ongoing care, and should you set up a trust, can you rely on Medicaid? So it's part and parcel of the same question, just you ask it different ways. But basically, I think what you're both trying to say, and tell me if I'm wrong, and you'll learn over time, I hardly ever am. So that was a joke. So my wife doesn't necessarily agree with that, trust me, nor do my children. But nor does our elder care law team as well, just for the record. I only know one, but anyway. Basically, what you're both asking is, if my spouse unfortunately needs 24/7 care at home in a nursing home, how can I avoid going broke and keep some income, keep some assets, keep the home? That's really what you're both asking in different ways. Is that fair to say? Okay. All right. Got it covered. Anyone else? Yes.
Norma.
Your name?
Yeah, Norma.
Norma.
And I've done a lot of the trusting and the estate planning, but I am, and my husband is at the beginning of this disease, and I am hoping to keep him at home as long as I can. However, it's hard to get into these institutions later on unless you go into independent things. So I'm trying to find out how you keep your loved one for as long as you can, and then find a way to get into a nursing home. So in many ways, is what they are also asking. How do we keep
Norma is asking, how do I keep my husband, I'm assuming, right, who has dementia?
Right.
Okay. How do I keep and he's at home with you, I'm assuming, currently. How do I keep my husband at home, cared for as long as possible? And if unfortunately, he needs care outside the home, what resources are available to pay for it? And but in the meantime, what resources are available to keep him at home? Is that your question?
Yeah. And how to get him in an institution at the last minute
Right.
or not last minute.
And how to transition to a nursing home setting, assisted living if appropriate. Okay, got it. Anyone else, sir?
We're here for our mother,
And your name?
Mike,
Mike.
and she was recently diagnosed, I guess, with Alzheimer's. And I became aware that there might be some benefits. My father's deceased, but he was a veteran. And there might be some benefits to the VA if we could tap into it, if we could provide some light, shed some light on that. And of course, all of our other, we have the same concerns with everyone else about keeping our mother as home as long as possible, and not draining her assets
Okay.
in the process.
All right. So Mike and his lovely
Phyllis,
wife,
my sister.
Phyllis, have a concern regarding their parent, and the question is, what benefits are available through the specifically VA veterans benefits, VA benefits, and to keep her in her own home, and what other services are available. And I will address that as well. Anyone else? Yes.
My name is Mary Ellen. My husband has always taken care of our investments. I need to move it to a professional, because I've never done that before. It's time to look at our wills and figure out where the assets are going to go. And I wasn't sure of the new things I should be adding to the existing will. And I don't know.
Good enough.
Start with that.
And before the program began, Mary Ellen?
Yes.
Mary Ellen mentioned to me she was interested in attending a program about digital assets, about estate planning for digital assets, and I'll touch upon that as well. But her question is, based upon unfortunately my husband's dementia, do I need to update my will? Do I need specific clauses based upon my spouse's condition? And I'll touch upon that. Anyone else? Yes, sir.
Okay, my name is Sue. How do you protect from identity theft? Okay, these days I'm getting a lot of spam calls, and one day I found out that my wife gave out her birthday. So is there any way to protect from those?
So, Sue's question was regarding identity theft. How do I protect my wife who has diminished capacity due to Alzheimer's or related dementia, I assume?
Right.
And how do I protect her from identity theft or from basically being taken advantage of due to her current mental condition?
Right.
That she is not cognizant of some of the impacts of some of the decisions she is making.
Right.
I will touch upon that. Yes.
My name is Deb. My husband has early onset Alzheimer's, and we still have children in college, and he's no longer able to work. Are there particular things for younger families that are encountering both lost income during sort of still raising kids and a spouse or parent who can't work and also needs care?
Excellent question. Not that the others were not, by the way. The question that Deb asked is, unfortunately, her husband, spouse, has early onset dementia, and she has children who still she has to pay for college for, or college financing is still an issue. And are there any specific type of planning specifically related to, say, individuals under age 60 with a spouse with early onset dementia? And how does that differ than someone who's 85, 90 and has Alzheimer's or dementia? Is there any different planning that you should look at for with younger couples and children who they still have to figure out how to pay for college, while at the same time gearing up for potential ongoing care that may be quite expensive? That
That's
crystallize
it.
your question?
That's it.
Okay, I can touch upon that. Yes, sir.
Name's Tarleton.
Charles.
Tarleton.
Charleston.
Tarleton.
Charlton.
Okay.
Okay. I was going to say I was there just a month ago for a conference, but it's Charlton. Okay.
And I'm worried about Medicaid. I understand that combined, we may not be eligible for Medicaid, but if they partition the assets, that there's a possibility that we may be eligible. Is that practical? Can that be done?
The question is from Charlton related to Medicaid is what are the eligibility rules for spouses?
Mhm.
And if you you mentioned partition, I'm assuming what you mean is taking half the assets.
No.
So I'm not sure what you mean by
Maybe 60-40 or 70-30.
Okay, we'll talk about what the eligibility rules are in spousal cases in the Commonwealth of Pennsylvania.
Right.
Okay, so and I'll be happy to address that question. Thank you. Yes.
Hi, my name is Hazel, and along the same lines of taking care of my husband, I was wondering about Medicaid annuities. Could you address that so that if you are over the amount allocated by government or the state, how one can protect those assets?
I will be happy to. Hazel asked, well, she's heard about the concept of Medicaid annuities as an asset protection strategy when one spouse needs ongoing 24/7 care. And she asked if I can touch base about the use of Medicaid annuities in expediting Medicaid eligibility.
I was really referring more to nursing home.
I understand.
facility, but that also, I hear something else too, which you probably will address. When you said home, when you said about being home.
I will certainly address
Thank you.
your concern. Not a problem related to nursing home care and Medicaid annuities. Anyone else? Okay, it's a good start. All right, we'll be here till the midnight buffet based upon this 7 questions. So buckle up. So let me just kind of give you an overall introduction. To tell you a little about what I do. So I mean, I was going to do a formal PowerPoint, but I tend to be informal. So if you have any questions, just shout it out, okay? And you know, I mean, I can do a whole PowerPoint, but to address what I think you want to hear. But I asked the questions, and I appreciate 7 or 8 of you volunteering, because rather than assume what you want to hear, I'd rather know what you want to hear, and that's why I asked those questions. So I'll address my remarks to answering those questions that will be incorporated, I promise you. If I don't specifically answer your question that you asked, or you have another burning desire to receive an answer, just shout it out. This is give and take. It's not me pontificating for the next 90 minutes. Fair enough? Okay. All right. So, and thank you for Kara from our office, our external marketer, for helping us set up as well. So a little about myself and understand where I'm coming from, because I think that will help crystallize some of the issues. And my personal story. My personal story is, where's the book? Is contained in the book that I wrote and published back in January. It's called The Unintentional. Not that. That's a whole lot of nothing. But it's a resource guide. It's a resource. But it's called The Unintentional Advocate. It's sitting there in the back. And the unintentional advocate is me, by the way, in case you were trying to figure that out. And a little of my personal story to understand where I'm coming from. Been doing elder care law for 20 years. And why am I, and people ask all the time, Jerry, why are you doing elder law? Well, why'd you choose that path? I've been a practicing attorney for a little less than 30 years and practicing elder law for 20 years. So I was working in a Center City law firm doing personal injury work and some other civil litigation. Hated it completely. And for about 9 years after law school. And about 9 years back in the late 90s, into my law career, I received a call from a woman who was distraught because her husband was in a nursing home in Delaware County, and she received all these bills, and she was like, well, why do I have to pay for it? Why isn't it covered by Medicare or Medicaid? And I said, all right, let's see what we can do. So that was my first foray into elder law back in the late 90s. And I couldn't wait to leave that firm, so we have 5 children. So my daughters were born in 1998. They're now 21, and so I understand the college funding issues. Trust me, we have other twins who are about to enter their freshman year of college. So bless you.
Thank you.
So and I decided I decided that that's an area of law. It's kind of exciting me. I didn't have no idea why. In retrospect, looking back, I didn't have this fascination of I love seniors. No, I mean it was a way I could put food on the table for my 1-year-old twins, and my wife, who has her master's in education. She hung up her master's of education shingle and never went back. And to raise our children and works out of the home since. So I had to make money, so that's why I did it. But really what started out as a way to put food on the table, I realized there's something about this area of elder care law that really excited me. And I really wanted something, and it gave me an opportunity and fulfillment, not so much a monetary fulfillment, but a personal fulfillment that didn't exist in my previous legal career. So that was my first foray into elder care law. And looking back on it, I think I did it because people think, oh, well, it was based on personal experience. For example, I have several elder law colleagues across the country who are in elder law, or they work with special needs children because they have a child with autism. And that's a perfect reason to morph into that. You learn by doing it, and then you kind of make a career out of it. So, but in retrospect, I think, and I do it now, and I think I'm a staunch advocate for seniors and those with disabilities based upon a personal experience, which I didn't realize at the time, because I can say I didn't want people to learn from my mistakes. What do I mean by that? I mean, all right, I'm not talking about mistakes with with clients. I'm talking about this is before when I even was a baby elder law attorney. My grandmother had Alzheimer's disease. And when I was in I grew up in Northeast Philly, so when I went to Washington High, so when I was in high school in Northeast Philly, and then when I was in college afterward at Syracuse, I used to come home and used to visit my grandmother, who was at the old Jewish geriatric home. And my father recently passed away in his late 50s then, and I decided every time you go there, who are you? Well, when you coming back? Or why? After a while, she had no idea who I was, and I said, well, why? And it made me kind of miserable and sad. So I was like, why should I go there? Why should I visit my grandmother in this nursing home? So, looking back at that, dealing with families, many individuals like yourselves, caring for a parent, caring for a spouse, caring for a sibling with Alzheimer's and related dementia, looking back, and how selfish can that possibly be? I mean, how awful was I was back then? So I guess in the back of my mind it was that, don't learn from my mistakes, because it doesn't, as you know, and again, some of you are working, have loved ones with early stage dementia, end stage dementia, or probably somewhere between. So you're probably all over the map here. And one thing that is paramount no matter what, it doesn't matter if they don't remember. You're there for them, and that's what matters. And that's all that matters in the end. And it's you get something. You get to be a caregiver, and that means something to everyone in this room. And for that moment, and they may be in the moment, they may not remember it, but it's the human touch. It may not make a difference, especially those who unfortunately have loved ones with end-stage dementia, that they may not remember you there the next day, but who cares? It doesn't matter. So that is what I've learned, and that's probably kind of when I make up for lost time. So that, to a certain extent, in the back of my mind, I didn't realize at the time, it's probably I do what I do. So the fact that you're here is you care, and you're there. And so good for you, and you're here to learn about available resources. So since that time, that's all we do. We have offices in PA and New Jersey, and some of you may probably have seen an elder care lawyer, and I emphasize elder care, by the way, as opposed to elder law for a reason. Care comes first. It's about care. It's not about money. It's about care. Money can access that care, and we'll talk about that. But care comes first, and that's the motto in our office. And we're a little different than most attorneys, let alone elder law attorneys. We have 5 geriatric social workers in our office, and Allison has worked with several of them over the years on behalf of her patients and our clients. And the goal is to get the best care, and then we'll figure out how to pay for it without going broke. So we look at it as a holistic type of practice. And over the years, really what our practice has morphed into is not law. I tell people I'm a lawyer 1/3 of the time. I'm a social worker probably 2/3 of the time. And I wouldn't have it any other way. Because I'll explain over time, you can have the greatest trust ever invented with wonderful words. It's so poetic. It covers everything you need. But how is that going to access durable medical equipment for your loved one? How is that going to facilitate the transfer of your parent to an assisted living community when your parent doesn't want to leave the home? So it's a piece of paper, in other words. So it's not about paper, it's about navigation. So about 15 years ago, I made a business decision. I was not happy practicing law the way I was doing it. And the reason I wasn't happy practicing elder law the way I was doing it, because I did not feel we were providing a good enough service for our clients or their caregivers like yourself. So 15 years ago, we brought our first geriatric social worker into our practice. We now have 5 geriatric social workers. Why do we have geriatric social workers? Because we are contacted on a daily basis by caregiver loved ones like yourselves, and we help you navigate. So, from an elder law, elder care, and really what we do now, we're healthcare advocates, and I'll explain what that means as we go to address some of your questions. So that's kind of a flavor of what we do, and the motto is get the best care and figure out how to pay for it. So what I like to start out with our discussion, a more substantive discussion, is, and one of my favorite websites I like to go to, because I don't have much of a life, so I like to read about public policy, and specifically, I'm a sucker to study healthcare delivery systems, specifically related to the aging process. I've studied the healthcare delivery system in Israel. I was there a few weeks, and I spent a couple weeks in the Netherlands studying their delivery system. And by the way, which healthcare delivery system did I find better than ours, by the way? So I'll leave that alone for another time. But what I would argue all of you are reluctantly are forced into is our convoluted healthcare system related to Medicaid, related to Medicare, related to Medicare HMOs, related to veterans benefits, related to are you an inpatient or are you under observation status in the hospital, related what's rehabilitation, what's subacute. It's all, you are all thrust into our healthcare system, and you're all in this together in caring if you are, again, a public policy, healthcare public policy buff like myself, I strongly suggest you logging in at least once a month to Kaiser Health News. Great, okay? It's a liberal think tank, so it depends how your policy is skewed, but I'm a big fan of Kaiser Health News. And there was an article, the May 2nd article in Kaiser Health News. The article was entitled, "Even Doctors Can't Navigate Our Broken Healthcare System." Did you see that? Allison's shaking your head. So, the article was about a doctor, gentleman whose whose father was a retired physician, and the Dr. Hassan Shanawani is the gentleman's name. The son's name, and he's also a physician working with the geriatric population for the federal VA system. And it was about his dad, who had stage 4 cancer, was in a hospital in New Jersey. It doesn't mention the hospital, just for the record, in New Jersey. And it was about that 2 educated individuals, 2 physicians, one practicing physician who works in regulatory policy through the Veterans Administration, and a retired physician, had a very difficult time navigating the healthcare system for this patient dad in his 80s with stage 4 cancer. And for example, he was trying to understand why his father was under observation status in the hospital as opposed to an inpatient. And what's the significance? Well, there's no Medicare coverage if you're under observation status. If you then go to rehabilitation, you lose up to 100 days of Medicare coverage, for example. So, and it goes. He never got a reason why, and it goes on and on as to the different obstacles he faced. And so, basically, he became a Twitter sensation because a lot of people picked this up, and everyone started following this VA physician on Twitter with outrage at the lack of answers and the obstacles for what he believed was two educated people trying to deal with our healthcare system. So, and basically his conclusion was, if myself and my father, 2 educated physicians, cannot figure out the healthcare system that we're charged with advocating for our patients every day of the week, how the hell could lay people navigate the system? And so I didn't make copies of it, but you can just go on the Kaiser Foundation website and pull it up. So as I said before, you're here about navigating the healthcare system. So let me start with, I will address your questions. And let me start with, what do I do for families? And let me just paint a picture for you. And maybe this would apply in your situation. Let me give you a typical type of case that we deal with. More of a case study. And then I'll parcel it out to address some of your questions. Fair enough? So let's assume children come to me, as well as a spouse, for a husband and father who is 88 years old, was diagnosed with Alzheimer's disease 5 years ago, and it's progressively worse. Let's assume a typically middle-class couple. They own a home valued at $250,000, and they have $300,000 in lifetime savings. And fixed income of Social Security, maybe a small pension of $4,000. I would consider that, say, a middle-class individual. Everyone's idea of middle class is different, of course. Fair enough? So they're on a fixed income. The husband is at home. However, he's now incontinent. He is having a more difficult time with mobility. He's up at night. He can no longer be left alone. So the wife is pretty much a prisoner of her home, in other words. And he sits there and watches TV every day. and doesn't really, other than with his wife, doesn't really receive socialization. He was hospitalized due to a fall. He broke a hip because he tripped on some carpeting, and he was hospitalized. And then he came back home and had some inpatient in-home care covered by Medicare for a period of 3 weeks, and that was about it. So they come to me. That's the typical case that we get. So they come to me, our office, and the first question I ask them is, why are you here? What's your pain? And usually what I get from the 80-some-year-old spouse is, my kids brought me, everything's okay. Yeah, right? Fair enough? You know, I'm okay. I can pick my 195-pound husband, I can pick up like a feather if he drops. You know, and the kids say, Dad is falling more and more in the home. You know, Mom can't pick him up. We're at work. You know, 911 has been to the house. And 911 basically is our home care agency. The police and the EMTs know Mom on a first name basis. Anything sound familiar? So what are your concerns? Well, our concern is, can I keep my house? Can I, you know, I can't afford $13,000 a month in the nursing home. And so I gather more and more information. I get, my husband is served during the Korean War, so that means he's a veteran. And I heard about these aid and attendance VA benefits. Is that possible? You know, my neighbor told me adult medical daycare would be appropriate. Does that make sense? Because it's $100 a day, we can't afford that. So, are there any benefits that can cover adult medical daycare? And my sister, unfortunately, is in this nursing home. Do you know how much that costs? That's $7,000 a month. We can't afford that. And on our fixed income and our savings, and so I asked, well, tell me about what your average day is in the home. I'm talking to the wife now. She then goes on to say, well, I don't get much sleep because he's up. He goes to the bathroom. I'm concerned about him falling, so I don't get much sleep during the night. And the kids and their fear is that, well, I'm afraid that, you know, mom's the emotional toll and the lack of sleep is really getting to her. And, you know, we're not that concerned about the finances. We don't want that money. I mean, we don't want the kids' money. I mean, we don't want the parents' money. That's for them. So how can we protect Mom if Dad needs assisted living nursing home care? How can we protect Mom to make sure the house is protected, to make sure she has more assets, more income, and what benefits are available through the Veterans Administration, through our insurance if possible, or through Medicaid, as some of you already questioned, and I'll address that. That's the typical case. Does that sound vaguely familiar to anyone? Okay? And I mean, they're all differentiated. I had all situations. So I'm going to come back to that example, but to your example about younger, I had a 58-year-old spouse come to me for a 63-year-old parent with frontal temporal dementia Tuesday. Okay? So with college-age children, and so that, by the way, that issue, that type of dementia, you may have seen on 60 Minutes, by the way, on Sunday evening, right? Some of you are shaking your head. So those are the issues that we deal with. Our job is to provide solutions. So let's get to some solutions, shall we? And I'll try to incorporate your questions, okay? And if I don't, yell at me. Fair enough? All right. So what do we do? So the first thing, a couple of you mentioned estate planning. Let's talk about estate planning first, and then we're going to work our way down. So what do I do? And what do elder law attorneys do? So the first thing we want to look at when in a planning situation, we can take lots of different variations, whether you're young, whether you're 60, whether you're 90, or somewhere in between, early stage dementia, end stage dementia, or somewhere in between. The first thing you always want to do, I always want to look at what estate planning documents do the individuals have, okay? And beyond that, what documents make sense? Well, to answer that question, you have to, or I always want to look at family dynamics. So what makes sense to do is really dependent upon what the family dynamics are. What does that mean? Have you been married 5 years, or have you been married 55 years? Are you single? Are you a widow? Are you divorced? Do you have children? Do you have local children? Have you ever been married? Are you estranged from your children? Are you what I would refer, if you have no one local to assist you, what I typically like to refer to as an unsupported elder. Others would refer to them as elder orphans. I don't like that term. And do you have children? And if so, do you have any child with a disability? In other words, do you have a special needs child with cerebral palsy, with autism, adult disabled child I'm talking about? Those are specific planning issues that need to be dealt with. So when you look at estate planning and planning, I want to understand what the family dynamics are. Because guess what? Believe it or not, children are a resource. In some cases, they can be a liability. I get that. But generally speaking, they're a resource. Just like Medicaid is a resource, and we'll talk more about that. So the first thing that I always want to look at are, do you have a will? Are there financial and healthcare powers of attorney in place? Do you have advance directives? And if you do, I'll look it over. Those documents need to be updated. Every case is unique. For example, generally speaking, everyone in this room, including myself, everyone's over age 18? You might be close, but you're on the upside. All right. So everyone needs a financial and healthcare power of attorney in this room. It doesn't make a difference, and we're presumably relatively healthy, right? We don't have diminished capacity, presumably. So maybe, but okay, nothing diagnosed yet. So, and we want to get documents when we are healthy enough and have the ability to understand what we're signing. So let's take that for someone with significant cognitive impairment. You are spouse and spouse, been married 50 years, 20 years, one day doesn't make a difference. Just because you're married to one another doesn't mean you can make legal decisions for the other. And I'm sure most of you are aware of that. So you need surrogate decision-making documents, and you want to get them in place before a crisis arises. Because if you have, for example, if one of the spouses in my example, they have $300,000. If the spouse needing care has a retirement plan, a 401k, an IRA, and you're looking to spend down funds to qualify for Medicaid for certain benefits, the healthy spouse cannot access those retirement assets because it's in the other spouse's individual name without legal authority. Well, if it's end-stage Alzheimer's or dementia, chances are that spouse needing care is beyond the ability to execute those documents at that point. Fair enough? So then the next step would be guardianship, which I would get to. But so you want to get those documents now before a crisis arose. So with financial
Is that a power of attorney enough?
Well, depends what you're trying to accomplish. Okay. Generally speaking, if you have a general durable power of attorney for financial matters, that's more of an umbrella that covers all assets. But it depends what the document says. Not all powers of attorney are the same. Okay. but that's a very important document. That is the most important document we can have. More important than a will. Okay? Why? Anyone?
Covers when you're still living.
Right. Because it helps you live. My job is to help people live with dignity and provide relief during their lifetime. Dying is easy from a planning perspective. Nothing to do. Okay? All right, at that point. Living is the difficult part. Living is the hard part. There's a lot of good in that, but that's the difficult part. So the power of attorney is a living document. A will's great, but when is a will effective? Exactly. It's not effective until there's an event that occurs, right? Yes?
Just a little bit about that guardian thing.
I'm getting to it, all right? I'm getting, I promise you that. Did you have a question?
Yes, do they expire?
The question is, does a power of attorney expire? A power of attorney expires upon death, and then the executor or under the will then takes over, but it doesn't expire until someone passes. Now, I don't want to...
New one's created.
Excuse me?
Or a new one's created.
Well, yeah. I mean, it remains. I don't want to get into nitty gritty on the different types of powers of attorney because we can have an hour and a half discussion just on those documents. Generally speaking, a durable power of attorney continues in effect if someone becomes incapacitated at a later date, and it continues into effect unless it's revoked or a new one is created that revokes the previous one, and it terminates upon that individual's death. Okay, so. A will is important though. So I always want to look at what the will says. A will is important, but a will is important based upon the circumstances. If we have a married couple that comes to me, based upon that example, all right, living in the home, one of the first things we do in addition to make sure they got powers of attorney in place is I want the healthy spouse to update his or her will. Why? Generally speaking, if they have wills, they've been married for many years, and it says that all assets, if I were to pass, go to my beloved spouse, and then subsequently to my children equal shares. And that's typical. That's what most of you have in the room. That's what I have in the room. I have no idea if my wife has that, but that's what I have. Okay? All right? So, which makes perfect sense. But if there's a chance you may need 24/7 care, which is expensive in the future, and you want to limit the amount of assets the surviving spouse can inherit, if the healthy spouse predeceases the surviving spouse, you always want to look to update that will, okay? Because of that circumstance. And we're not transferring funds, we're just revising a will, which is effective at death, and then you would name your children. So you want to limit the amount of assets, generally speaking, the surviving spouse can inherit. Then, if there are no powers of attorney in place, and unfortunately, the spouse has significant cognitive impairment and is unable to execute the document, in other words, lack of legal capacity specifically, then a guardianship may be needed. You never want a guardianship. I try in our office to avoid a guardianship as much as possible, because no one wins when a guardianship is filed. First of all, you're now subject to the legal jurisdiction of, in Philadelphia or or the counties, it's the orphans court in the county in which you reside. So if you want to engage in any additional planning with the disabled individual's assets subject to the guardianship, you have to apply to the court. You don't want that. The power of attorney is a private document. So, but sometimes you can't avoid the guardianship. And you have to look at different circumstances from a practical perspective, whether a guardianship is warranted or not.
Could you define the word guardianship? Is that obtained through a court, or is someone is assigned to be a guardian, like a family or a document?
The question is, what exactly is a guardianship, and what's the process to obtain guardianship? The guardianship is a legal proceeding. A guardian is a fiduciary. You're acting in the best interest of a third party. It could be a spouse. It could be a parent. It could be a sibling. It could be a child in some cases. And the guardian is charged with acting in the individual's best interest. It's a court order, so that means it's a legal proceeding where you file a complaint. And
So
then
it's not a power of attorney?
it is absolutely nothing to do with a power of attorney. Typically, it's in lieu of a power of attorney. Because an individual, there are exceptions to the general rule, but generally, it is dealing with a person who is incapacitated. Now, there are situations, by the way, where even though you have a power of attorney, you still need a guardianship. Any idea why? You've heard of circumstances, and I'm sure you can imagine. A power of attorney is a powerful document. You're an agent, so what may an agent do? Think in an unscrupulous manner. You may spend the disabled individual's money that you're charged with protecting. Well, if the agent under the financial power of attorney is abusing his or her authority, one way to terminate that authority, if the individual is already incapacitated or then unable to terminate, is having a guardianship filed. So normally you don't need a guardianship if a power of attorney is filed, but sometimes you may. Okay? So it's unusual, but I've seen it before, and I'm sure I'll unfortunately see it again. But generally, you want to avoid the guardianship. It's a legal proceeding. It's time-consuming and an expensive legal proceeding, and you don't want to go to the court if you can avoid it. And that's just a general rule of life. Avoid the courts if at all possible. It's never a good result for anyone. Okay? That's a last resort. Sometimes you have to, but generally you want not. So in other words, you need a decision maker, whether it's in some capacity, to do any types of planning. Generally, you want a financial health care power of attorney. And the other option, and then I want to look at, someone comes to me. I want to look at housing options for them. What's the goal? I can recommend all different things, but what are you trying to accomplish? And the response is, I want to stay at home for as long as possible. Well, how are we going to make that happen? Or I want to move to an assisted living. I want my loved one or move to an independent living or assisted living community. How are we going to make that happen? We also want to look at different agreements. If the issue for that spouse is, we really need nursing home care at this point, well, I need to review the admission contract, to review that 30-page nursing home admission agreement to make sure that it's okay to sign. So, but in that situation, but let's take the situation of they're at home now, and then I'll change the example and say nursing home care is needed or assisted living care is needed. Okay, but they're at home now, and they have $300,000 in assets, and they would like to work. One of our geriatric social workers goes out and assesses the individual, and they say we want to bring in home care. Okay. Or maybe adult medical day will make sense. And how that is going to be paid for. Well, yes, you can use your own money. First of all, as you probably know, health insurance does not cover long-term care. Your Medicare coverage does not cover long-term care. Medicare covers little to none home care, and with certain exceptions, especially if within the first 3 weeks of discharge from a hospital. Medicare does not cover independent living. Medicare does not cover assisted living. In PA, it's called personal care, generally speaking. And Medicare only covers up to 100 days per period, which theory it's just 100 days in 1 year. 100 days of Medicare coverage. That's a maximum, not a guarantee. In a nursing home setting. After 100 days, or if you're deemed to be no longer in need of quote-unquote skilled care prior to the expiration of 100 days, it's private pay, say $400 or so per day. So Medicare is not the tool to keep someone at home, or out of a nursing home, I should say, because it doesn't, independent living and assisted living. However, there are circumstances depending on the situation, where you can look at other benefits. One of the benefits, this gentleman that I gave is a Korean War veteran. So we can look at the VA potentially. The VA, there's different benefits through the Veterans Administration. The benefits can be available to the veteran, mainly it's himself, but I don't want to discriminate. It could be herself. On an occasion, happens once in a while in our office. But usually it's the husband, of course. And it also could be for the widowed spouse of the eligible veteran. If the widowed spouse was married to the veteran at the time of his or her passing. Okay? One of those two sides. And the VA can help cover home care, adult medical day care, or assisted living and personal care. There's different programs that are out there. Okay? And by the way, I think in your folder is our VA nuts and bolts guide. So I'm due to time constraints, I'm not going to go into full details of the benefit, but the full details of the benefit should be in each of your folders, the VA nuts and bolts guide. Okay? So, but in short, if there are certain requirements to be eligible for VA benefits, and the specific VA benefit I'll mention over the next few minutes is called the Veterans Aid and Attendance Benefit. It's for veterans who served our country during a time of war or widowed spouses of those eligible veterans. And it could be a cash, or I should say a tax-free income, additional income above whatever income they're receiving now. And for the veteran with a spouse, the benefit could reach over $2,300. For the widowed spouse, in other words, a single individual, the benefit could be about $1,300. The specific amounts are in your nuts and bolts guide. It could cover home care, it can cover assisted living, cover nursing home care. However, the important part is this. The eligibility rules have changed effective October 18th, 2018, just about 6 months ago. In order to be eligible, there are now transfer of asset rules that apply for the VA benefit. If you're not a veteran or widowed spouse, this is inapplicable to you. Understand that, okay? So it doesn't apply to for everyone. And it applies for World War II veterans, Korean War, Vietnam War veterans, or Persian Gulf War veterans. Okay? Most of the people that we're seeing today, we're getting to the tail end of World War II, and the majority are probably Korean War and some Vietnam War. Okay? And the benefit is, I said, generally between $1,300 to $2,300. But the eligibility rules, financial eligibility rules are this. Total assets for the single veteran or spouses have to be no more than $126,000. Okay? The home is an exempt asset from that $126,000 limit, and a car is exempt. So if you're above the $126,000, you're not eligible for the benefit. And if you give away money, in other words, you transfer money to a trust or to a child or anyone else, there would be a 3-year look back that applies. Not Medicaid 5-year look back. I'm not talking Medicaid, folks. Okay? A 3-year look back that applies. That is effective October 18th, 2018. Just recently. Okay? So in the example I used with the couple has $300,000 in assets, they would not be eligible for the benefit. You can give away money, but you have to wait up to 3 years to receive the benefit. Now, let's take a different example. Let's assume they have $150,000 of assets and the home. Well, they would only have about $24,000 or so to spend down at that point. So they're much closer to eligibility. So they would have to. So if you give away money, you would have to wait a certain period of time. So that is the general rules on VA. So, are you eligible? Well, it depends on the situation. You have to see what your financial situation is, or whether you're eligible or not. Now, Medicaid. In this case, the goal is for that couple to remain at home. And let's assume, and that I mentioned that they had $4,000 in fixed income and $300,000 in assets. Let me talk to you the general rules regarding Medicaid. This isn't a home setting, but the same general rules apply in a home setting as in a nursing home setting. Okay? We talked about Medicare. We talked about VA. Let's touch base on Medicaid now. Okay? So the rules differ whether you're a single individual or a couple. But here are the general rules. But when you have a general rules, what also are there? There are all exceptions to the general rules, right? My job is to work within the system to get the best result. But understand what our theory is when I say our Rothkopf Law Group's theory on Medicaid. Medicaid is not a destination. No one relishes being eligible for Medicaid. At least I don't think anyone in this room. Okay? But in some cases, it's default long-term care insurance. It's just a fact. Our office's goal is never about Medicaid. Our office's goal is always to effectuate the client's wishes and put them in the best care and financial position, with Medicaid being a tool to accomplish that goal. But it's a tool, just like VA is, just like your family is, just like using your own money is. Okay? So, that said, let's talk about the example with my clients with $300,000 in assets plus a home. Medicaid has a 5-year look back. I mentioned a 3-year VA look back earlier. But Medicaid has a 5-year look back. So what that means is that if you give away money, generally you have to wait up to 5 years to apply. Okay? So, does it make sense to give away money? Maybe. I mean, let's take your situation, okay? The younger couple in their 50s, 60s. Sometimes it's if you have a significant estate, everyone's idea of significant is different, of course. And you have assets to protect, and maybe you have not had the opportunity to purchase long-term care insurance, and you have a diagnosis of Alzheimer's or related dementia, you can't purchase insurance, at least for that individual. Maybe the healthy spouse can. In that case, maybe you'll wait 5 years, gift away money, possibly fund an irrevocable trust that was mentioned earlier, and wait 5 years, and put $500,000 into the trust. Maybe that makes sense. But or whatever into the trust amount into, and wait 5 years if that makes sense as a pre-planning tool, which we do often with our clients. But the general rules, then I'll take some questions. Let me just get to the general rules, okay? It gets a little convoluted. The general rule is the healthy spouse gets to keep up to $126,000. Does that sound familiar? The VA bogarted Medicaid rules, basically, is what it boils down to. The healthy spouse gets to keep $126,000, the home, and 1 car. Okay?
And retirement accounts?
I didn't get to that yet. Thank you. Okay? And in the Commonwealth of Pennsylvania, not in New Jersey, by the way, just 5 miles away or so, the healthy spouse's qualified retirement funds are an exempt asset. Okay?
Is what?
The healthy spouse's qualified retirement funds are an exempt asset for Medicaid eligibility purposes in the Commonwealth of Pennsylvania. So, if in my example, if the wife, the non-Medicaid spouse has $150,000 IRA and lives in the Commonwealth of Pennsylvania, and that's where the care is going to be rendered, that $150,000 IRA doesn't count to the Medicaid eligibility limits. So, It's $126,000. The home is an exempt asset, 1 car, and the non-Medicaid applicants qualified retirement plan, be it an IRA, 401k, etc. Got that? So, not all states are the same. New Jersey's different, as I said. New Jersey, the Healthy Spouses Retirement Plan is part of the pool of money. It doesn't make a difference who owns the asset. As spouse and spouse, it's one pool of money.
How about
Okay?
Delaware?
Excuse me?
How about Delaware?
Delaware, I have no idea. I don't practice in Delaware. I can't help you. Okay? I do not know.
All right.
I practice in the Commonwealth of Pennsylvania and the state of New Jersey. Delaware, I'm not touching because I don't practice there. Okay? So and the Medicaid spouse, the spouse who you're applying for Medicaid gets to keep total assets depending upon income levels of either $2,400 or up to $8,000. The difference between $2,400 and $8,000 is your income. If the Medicaid applicant's income is above the threshold of $2,313, then you get to keep $2,400. It's below $2,313, you get to keep up to $8,000. So $126,000, $8,000 retirement account for the non-Medicaid spouse, and the home and 1 car. Got that? That's the general rules. So, and we have a 5-year look back with the general rules. So but of course we have situations that are unique and different. We have to look at what we're trying to accomplish. For example, so I may recommend for that client with the $300,000 to engage in Medicaid planning because they're looking for care at home, they're looking to pay for adult medical daycare, but the goal is to stay at home. So I may say to that client, here, you get to keep $126,000. You can keep $2,400. The spouse needing care. All the other assets must be spent down to zero. Well, how are we going to spend down $150,000 or so, give or take? Right? That's the kind of the magical question, right? I'll tell you. So first thing we do is what are you trying to accomplish? If you transfer money to a child, it's part of the Medicaid 5-year look back. But not every transfer to a child results in a penalty period applying for up to 5 years that you're to be ineligible for Medicaid. Why? Because of the general exceptions to the Medicaid eligibility rules. Lots of exceptions. It gets complicated. One of the exceptions that we look to, I mentioned it earlier without saying it. I said we need to look at family dynamics, if you recall, right? Mm-hmm. One of the exceptions to the eligibility rules is transfers to a child with a disability. When I say a disability, say a 55-year-old child with autism who's collecting Social Security disability, for example, or has had an acute situation and is unable to work and is collecting SSD. If you have proof that the child is disabled, assets can be transferred outright or in trust for the benefit of that disabled individual, exempt from the Medicaid 5-year look back. Whether or not to do that, you have to look at the facts. In all cases, it may not make sense. But let's assume, though, that that's one way to get rid of $150,000 and immediately qualify for Medicaid to cover home care, to cover adult medical daycare. Remember, in Pennsylvania, there is no Medicaid coverage for what is known as assisted living or personal care. So if someone's moving to assisted living or personal care in Pennsylvania, there's no sense looking to qualify for Medicaid. So that's why I say, what are you trying to accomplish? Because you get butt kissed for a Medicaid. You get nothing. However, you go 5 miles away to New Jersey, there is Medicaid coverage for assisted living in the state of New Jersey. So sometimes when someone is looking for assisted living and assets are relatively limited, since we do work in both states, we may say, well, you might want to look at some assisted living communities not too far from the Delaware River. You know, so for example, we have clients living in Yardley. We have clients living in Northeast Philly. You know, they're 5 minutes from the Tacony Palmyra, or they're from Yardley to Trenton is 15 minutes, say, or something like that. So we say, well, why don't we look at New Jersey? It's not that far away. We'll see what makes sense for you, and then we can potentially transition to Medicaid eligibility in the future if that's the right thing to do. So now, let me get to that annuity question that I think some woman in the back asked, right? So there are different planning tools you can utilize. Not every planning tool makes sense, but there is what's known as a Medicaid annuity. And I don't want to get too far into the weeds on this, but let me just talk the basics of it. There exists what's called a Medicaid annuity, which generally is purchased by the healthy spouse. The healthy spouse, and let's use that example when $300,000. Let's assume they spend down some money. Before you purchase an annuity, look to spend money on stuff. So I encourage families, purchase something that you need if you're looking to spend down funds to qualify to the Medicaid numbers. What do people need sometimes out there? I'm sorry, shout it out. Medical equipment, is that what you said?
Yes.
Yeah, maybe
Wheelchair.
maybe a specially equipped wheelchair, maybe a stair climber, maybe a hospital bed, in some cases, a handicap accessible van, depending on someone with ALS, for example. So it depends. And what else does everyone need eventually?
Vacation.
Yes, you can spend it on yourself. Way to go. You can spend it on a vacation. You can spend it on you, which is not always a bad thing, by the way. So we mentioned spend it on a vacation. Yeah, spend it on something fun. It doesn't have to be dreary. But yeah, I wasn't thinking that, but you're absolutely correct. I should have been. Yeah, spend it on something fun, something you enjoy. It could be furniture. It could be any personal property. Now, you got to be careful what you're spending it on, though. Remember, if you're taking a Disney vacation, and by the way, Disney and vacation are, in my mind, those words should not be utilized together. But that's beside the point. We can debate that later on. That's work. Anyway, but if you're doing on a multi-generational vacation somewhere, say in Jamaica, and you want to have a bunch of people, you can't pay for everyone. You can't pay $25,000 for everyone. You can pay for you and your spouse. But if you pay for everyone else, arguably the Medicaid agency may consider that a gift within the 5-year look back. But spend it on yourself. What else does everyone need, by the way? Hopefully not anytime soon.
Funerals.
Prepaid funerals, you got it. Everyone's going to need a funeral in some sort, from cremation to John Gotti flotilla down Broadway or somewhere in between. So if you set it up in a prepaid burial account, the money that you deposit in that account is an exempt asset for Medicaid eligibility. Okay, so it doesn't count in other ways. So there are other exceptions as well. And the last thing you would do then is purchase that annuity. Why does it work? Because federal law says it works. There are specific bullet points that you must meet. If you go to your financial advisor and you ask for I need to purchase a Medicaid annuity, they generally will have no idea what you're talking about, because they don't typically deal with these types of annuity products. These are specific annuities. Sometimes they're referred to as SPIAs. S-P-I-A. What does that stand for? Single Premium Immediate Annuity. If you're healthy, do not purchase it, because the investment itself, for lack of a better term, sucks. Okay? You might as well keep the money under a pillow. It's the same result. Okay? But what this does, in theory, it creates immediate Medicaid eligibility by spending down funds to the Medicaid limit. So in they have 300,000. So let's assume they're 150,000 over in my example. The healthy spouse can purchase an immediate annuity for 150,000 and having a monthly payout in equal monthly amounts within that healthy spouse's actuarial life expectancy. Actuarial and actual are not the same thing, as you may know. So if the spouse is 86 years old, and let's assume the females always live longer, fair enough. Let's assume our actual life expectancy, let's assume is 6 years, let's say. 7 years. She can purchase anything less than 5 or 6 years. She can purchase it for 1 year and then get equal monthly payments of $10,000 plus a month going into her account. Because the money is now an income stream, it's no longer an asset. The healthy spouse's income is an exempt asset. That's why it works. You take an asset and you change it into an income stream. It's one of those things that, disclaimer, do not try this at home, because it's not as simple as it sounds. You have to make sure you have all the requirements of federal law in the annuity contract. So I have to review these annuity contracts to make sure it meets the requirements of federal law, because it doesn't. It's a countable asset. And now you're SOL, so to speak, because you're getting these streams of income, and it's an irrevocable election. So now you can't spend the money because you're getting it over a series of time, and you can't qualify for Medicaid. Questions? Let's start in the back and work our way to you, sir.
How much is the allocated for the prepaid funeral?
The question is, how much is allocated for the prepaid funeral? Each county in the Commonwealth of Pennsylvania has different amounts that they have a ceiling. However, the average is probably, without looking at memorizing the amount for each county, you're probably looking upwards of up to $16,000 that could be placed in the prepaid funeral per person, by the way, without it counting for Medicaid eligibility purposes. There are exceptions. For example, I had a couple, and the funeral was over $20,000. But it was they live in New York City, and you're paying New York City prices. So I had to explain that to the Medicaid office. Even though they lived here, they're from New York, and that's where they set up the funeral. And that was okay, because you had to explain, well, it's pricier in Manhattan than it is in Philly. Okay? Question, sir?
Yeah. So $126,000, right? So somebody has $226,000. The house is exempt. Could you take $100,000 and do home improvements, and that wouldn't qualify for that 5-year look back?
The question is that if you're over the $126,000 limit, can you take monies and put them back and do home improvements to the primary residence, which is an exempt asset, and spend down money? Yes is the answer to that question. You can do home improvements. You can put on a new roof. You can purchase furniture. You can buy a flat screen TV. You can paint. You can buy bedroom furniture, a new bed. Anything related to home improvement, if you put money into your own home. If you buy a home or improve your kid's home, no, with one minor exception. So what's that? What did you say? Anyone?
Disability. A child with disability.
Well, no. Well, that's true. But, wow, someone's paying attention. My Commonwealth with a child with a disability. I'm impressed. Yes. But what you also can do, I guess I have to stay here. I like to roam, but I don't think I can. Video. Anyway. Let's assume that you're aging, that your children live close by or somewhere, and they say, Mom and Dad, we want to take care of you. We don't think you're safe in your 4-bedroom, 2.5-bath home anymore. You have that chair glide thing, and it's really not. It takes you an hour and a half to get up the steps. You could have watched the NBA basketball game in that time. So, and why don't you look to move in with us? We'll take care of you, and we'll do an in-law suite. What do you say? The and bring your dog. Why the hell not? You got your kids, your grandkids are there, and it'll be a multi-generational. How fun is that? For some of you, it would be a living nightmare probably. I get that. So, but let's assume that happens. And $100,000 is used for like an in-law suite. Got it? And that's okay, as long as you have the paperwork in place. You would want a caregiver agreement between parent and child. What's that $100,000 going to be used for? You want agreement that this is going to be for home improvements. You want to specify that this is going to be mom, dad's space. So most people don't work, we're all human, right? It's family transactions. We don't know. We don't account for every dime we spend. We don't know. We're thinking, Mom, you need money, or kids, you need the money. Here's $10. Go to Wawa. We don't account for everything we spend. So, same thing. So most people don't just say, do it, but you want the paper. You want the paper trail. Understand? So there are ways to even with or without a child with a disability, by the way. Any other questions on that? Oh, lots of questions.
Not on that, but you made reference to sheltering money in a irrevocable trust.
Mm-hmm.
I just wanted to find out what is that.
The question is, I referenced an irrevocable trust. What is that all about? What can we do with that? Well, trusts come in all shapes and sizes. In the right circumstances, we will do what's called a Medicaid Asset Protection Trust. That's not a legal name, that's just what we call it. In which it's subject to the Medicaid 5-year look back. Where let's assume you have a couple in their mid-70s. One spouse was diagnosed with some form of dementia. They're concerned about protecting assets. So we'll take a portion of the assets and move it to an irrevocable trust, typically with a child as a trustee, subject to the Medicaid 5-year look back. So after 5 years, the money in that trust or any appreciation of those funds is exempt from the 5-year look back because it's outside the 5-year look back. And then you would look at what funds remain in the individual's name, the grantor who set up the trust. What assets remain to fund the trust? So, what assets can be used to pay for any necessary care? So it's an irrevocable as opposed to revocable. It's a living trust because it's set up during an individual's lifetime, but IR in front of revocable. And in that situation, because it's irrevocable, if you have the proper language in there about the principal and or income not being directly accessible to the parent, the money would be exempt from Medicaid eligibility financial requirements after 5 years.
Is there a maximum allowed for that?
The question is there a maximum allowed? Every penny you have can go into the trust. There is no maximum. The maximum is a practical maximum. If you have $5 million, am I doing this? Probably not. Okay? If you have $500,000, am I doing it? Maybe. Okay? At some point, for lack of a better term, the pig principle applies. You understand what I'm saying? Okay? Where is that? I don't know. But, I think you understand what I mean by that. At some point you can self-insure. At some point it just doesn't make any sense. But do you have long-term care insurance on top of your lifetime savings? So, there's several, or you're a retired school teacher. I'm a product of Philly Public Schools, and what does that mean? I'm a lawyer. Put those two together, what do you get? I can't add, all right? My math sucks, okay? So, but somehow, I did okay though, that's all right. So, survived, but in those situations, maybe you're a retired Philadelphia school teacher. What does that mean? Pension. Maybe both spouses are retired Philadelphia school teachers. So you have over $10,000 in income coming in a month, plus Social Security, and maybe some investments. Maybe there's and maybe long-term care insurance at $100 a day, $3,000 a month on top of that. Relatively small long-term care policy. So if you needed care, you're going to have over $15,000 coming in every month. maybe you self-insure. So you have to look at each situation. Granted, that's an exception rather than the rule that we see, but every case is unique. Some cases have minimal assets but sufficient income. So, but you have to look at the situation whether it makes sense. And you also have to look at other factors that you have to look at tax situation.
Are there any of these expenses that we are talking for tax deductible?
I'll get to the issue related to tax deductible in a bit, but to finish the discussion on trust, more and more retirees today do not have traditional pensions. They worked at IBM, they worked at factories, so they're not going to have traditional pensions like the World War II or Korean War veterans have, right? It's every woman and man for himself. You got to save. You have, whether it's through work or 401k or you have your own IRA, right? So in that case, more and more, what we're seeing for people who have a larger means, most of their savings are in qualified funds. So setting up an irrevocable trust may not make the most sense for those individuals because they have to liquidate their retirement account. And if you liquidate a retirement account, what do you then realize? Income taxes, right? So if you have $500,000 sitting in an IRA that just, and you're not contributing to the account anymore, you're taking what's called retired minimum distribution because you're beyond age 70 and a half. If you liquidate $500,000, throw it into an account, you have to pay income taxes. Well, that's not a great plan because now you're paying $200,000 in income taxes. Okay? So you have to look at what's the makeup of the situation, what the acuity level is, what your goals are, and then whether it's trust funding, Medicaid funding, and then we can put a game, or VA, and we can put a game plan together. Question was, and then I'll get to some other hands that went up. Question was, are any of these expenses that you're paying tax deductible? The answer is maybe. If medical expenses are paid for home care, adult medical day, assisted living, nursing home, the expenses can be medical in nature, and therefore you may be able to obtain a medical expense deduction. If you can only deduct from your taxes if you're paying taxes. So you may be able to use some of the long-term care expenses for the purposes of saving taxes as a medical expense deduction. Why? Sometimes I do that. For example, back to qualified funds, retirement accounts. If someone is in an assisted living facility, and as I already mentioned, Medicaid does not cover assisted living expenses or called personal care in the Commonwealth of Pennsylvania. Let's assume the assisted living community is $6,000 a month. Let's say $75,000 a year. Remember, I'm not very good at math, so I need round numbers, right? So, and you had to liquidate a $100,000 retirement account to pay that $75,000. Okay? Which then you're going to generate, say, at least $25,000 in a tax bill. But typically about 50% of the assisted living costs, especially if it's dementia-related costs, because not every assisted living is the same. You have a traditional assisted living, then you have assisted living memory care, some of you are familiar with, which is generally a higher level of services, higher level of care. It's typically 50, maybe 60% of those expenses are deductible, so maybe you're able to deduct up to $40,000. So if you can deduct in medical expenses up to $40,000, that will reduce the $25,000 tax owed. You got it? So there is some tax planning you can do to reduce the impact upon a large liquidation of a retirement account. I know some other hands went up. Yes?
Just going back to the VA stuff, I know there's some stuff there, just looking through it briefly, but I was on the phone with them for an hour just waiting to get through. Do you have the ability to get, short circuit that and not,
I can't say we short circuit anything. We don't contact the VA because we know how to plan. So we know what the rules are. So, we apply in-house in our office for veterans benefits for our clients or widowed spouses.
But you have the lessons learned and tips on how to do that.
Yes, depending. Yeah, We are experienced in filing veterans benefits applications for our clients, so that's what we do for a living. It's part of what we do. So I can't say we short circuit, so instead of, what I can tell you is, instead of you making 10 different calls on being on hold and getting nowhere fast, we just tell you what to, we just do it for you. So, but I can't say, I can't vouch for the fact that we're going to gain eligibility quicker than doing it on your own. I can't say that. But our goal is to navigate the system, inclusive of VA benefits, to ease the burden on caregivers, loved ones like yourselves. Yes?
In Pennsylvania, does medical assistance pay for care in the home under any circumstances?
I alluded to it. The answer is yes. I alluded to it earlier. There's different it's called Medicaid waiver program. So when I was referring to Medicaid eligibility at home, I was talking about a Medicaid waiver program for seniors needing long-term care. It's called the waiver program, that's one of the major problems that we have today with our long-term care financing system. There are many, but specifically related to Medicaid is that traditionally Medicaid is weighted to a nursing home level of care. Well, I think everyone in this room will agree, if I need care, I don't want to be in a nursing home, right? So, but for many individuals, Medicaid is necessary because of the high cost of care. So, especially for those with dementia, because Medicare does not cover chronic issues related to Alzheimer's and related dementia, as we already alluded to. So there's a program called the waiver program that will cover typically 5-6 hours a day of home care. But it's a Medicaid program, so the Medicaid eligibility rules apply to that program. And you also there's also an income cap, which is $2,313. If you're above the $2,313, you will have difficulty qualifying for the Medicaid that waiver program in Pennsylvania. But keep in mind, there's a large black hole that exists in home and community-based services for those with chronic illnesses who need ongoing support services in Pennsylvania. And that's as I alluded, there is zero Medicaid eligibility for personal care or assisted living currently in Pennsylvania, and that's kind of the black hole. So it's fine. Medicaid is not designed to keep someone who needs 24/7 care at home. That I can state as a fact. It's good for 5-6 hours a day. It can also cover adult day under the waiver program. But the same eligibility rules apply in a nursing home setting as they do under the waiver program for what's called home and community-based services. So the 126,000 limit, all that I mentioned before, does apply. Now, the home's an exempt asset. Of course, you're living in a home, but okay, all that applies. Yes?
You mentioned Medicaid and Medicaid annuity. You used the example of someone who's sick with a spouse. What if the person is a widow and you have children that are trying to help the mother? How would that apply then?
Well, it's more difficult planning. Why? Because when it's a married couple, there is what's called spousal impoverishment rules that apply. What are the spousal impoverishment? 126,000 is a spousal impoverishment rule. It prevents the non-Medicaid spouse from being impoverished. That's where the 126 comes from. And however, if there's no spouse, there's no spousal impoverishment rules that apply. So you're looking at a single individual, and that single individual is limited to either $2,400 in total assets or $8,000. If you're living in the home, the home is exempt asset. If the individual is already in a nursing home setting and owns a home, the home is an exempt asset as well. As long as the individual checks on the application for Medicaid that I have an intent to return home. That's not dispositive of the overall planning that needs to occur, because for every dollar Medicaid pays under federal law, state wants to be paid back from the estate of the Medicaid applicant. So If an individual is on Medicaid for 1 year, there could be a lien of $75,000 on the house. So even though it's exempt, it may get you on the back end, so to speak, if you understand what I'm saying. So you might want to still consider selling the home. But let's look at the situation though, and we do this all the time. Got a single individual, needs nursing home care. Have $100,000. Not unusual, that situation. With or without a home. You can still use a Medicaid annuity. It's just a little more difficult road to hoe. And it's a little more complicated planning. Basically, without going into too much detail to bore you to death, in that situation, using a Medicaid annuity, that individual can still protect about 50% of the existing assets. How? By purchasing an annuity with 50% of the funds, an immediate annuity, a SPIA, as I alluded to, by purchasing an annuity with 50% of the funds, and using the other 50% to as a gift. And if you crunch, once the numbers are properly crunched, the annuity money will pay the nursing home during what's called a period of ineligibility within the Medicaid 5-year look back. I know what you're thinking, if you're still paying attention. You're thinking, well, Jerry, didn't you just say there's a 5-year look back, so how does that help? Well, the 5 years is a maximum. For every about $10,000 that is gifted, you're ineligible for Medicaid for 1 month. So if you gift $50,000, I can figure out that now. Okay? You're ineligible for 5 months. What are you how is the nursing home going to get paid with during the 5 months? Via the Medicaid annuity. So you're under the $2,400 or $8,000, all the money is out, and the annuity is paying for 5 months. Eligibility for Medicaid, in theory, after 5 months, the money that's gifted is protected. Whether to do it or not, you have to look at the situation. Now, you may have a single individual. You can, it's not unusual. We have a single individual, and we have a situation where candles are burning on both ends. What do I mean by that? Anyone? Excuse me? They're both sick, but you got a child and a parent. You have an 85-year-old parent living with a 55-year-old child with cerebral palsy. They never have been separated from day one. You got an interdependency developing. So when I say burning on both ends, you have special needs planning for the 55-year-old. Unfortunately, mom needs nursing home care. You can set up a trust for the benefit of a child with a disability. All the assets in the house can be transferred to a special needs trust. Creates immediate Medicaid eligibility for the mother. Why can you do that? Because public policy says you can do that. That's why. Because they want to protect the child with a disability. They meaning the government. The government does something right once in a while. Okay? So that's under federal law. So there are different planning opportunities, and there's some things you need to do differently with a single individual. Another opportunity, there's other opportunities, whether you're for a single, or in some cases, usually it's a single individual. I can have, I'll look at a situation where if a child, I feel like I should start dancing. If a child is living with the parent in the parent's home, and the child renders a level of care to the parent to keep the parent at home, and the child resides in the home for at least 2 years and as the primary residence, and during that 2-year time frame, the child takes care of the parent, even if the child was working. Still got morning, still got the end of the day, night, and you still got weekends. Then the house, as long as you meet the requirements, can be transferred to the quote-unquote caregiver child, exempt from the Medicaid 5-year look back. That's called the caregiver child transfer of the parent's real estate. The primary resident. It's not the home in Margate, by the way, if it's not the primary residence, all right? It's not the shore property, folks. Got it? So it's only the primary residence. So, and another take on that is that, back to that parent moving in with a child, if the parent says has 150,000, single individual, I know looking to qualify for Medicaid for home care or adult medical day, the goal is to have the parent's primary residence be the child's home. With or without that home improvements I was talking about earlier, the parent can purchase a right to live in the house for the parent's lifetime. That's a legal interest. It's called a life estate. So, and depending upon the value of the child's home and what the mortgage is, if any, the parent can give the child a lump sum. If the parent gives the child a lump sum, it's for full value because it's for the right to live in the property. It's called, under the law, it's called full consideration. And if that is the case, the parent can then can reduce assets below the Medicaid limit if it makes sense, and look to qualify for Medicaid coverage for that waiver program that I previously mentioned. The caveat to that, and the important part, is that the parent must live in the home for at least 1 year. The parent must live in the home for at least 1 year after the parent gives the child the money for the so-called life estate. Sir?
What
Yes.
happens after that?
What happens after the 1 year period? The monies that is given to the child for the purchase of life estate is totally exempt after that 1 year time frame. Okay? If you survive the year, Medicaid's not going to go after that money. That's the bottom line. Okay? So it's a 1 year requirement. Anyone else? Questions? Yes.
Yeah, I have a question about gifting in Pennsylvania.
Okay.
It's like my understanding, you can gift up to $500 a month to one person. Oh, $500 a month max. Do you need to keep really accurate records, or?
Sure. The question is, in Pennsylvania, she heard that you can gift up to $500 a month. That is correct. You can. I don't like to tell people that because people misconstrue it. That's why I did not bring it up. People don't fully understand how it works. So I don't like people taking my advice and saying, start giving $500 away left and right. Okay? But you are correct. In the Commonwealth of Pennsylvania, unlike New Jersey, by the way.
I'm not just talking, I mean, for example, Christmas, birthdays.
I get that. I get the holiday gifts. I get it. So in the Commonwealth of Pennsylvania, the law allows up to $500 in its totality, not to each individual. It's not $500 to each of my 8 children. Up to $500 a month in the maximum. So it's $100 to 5 people maximum, in other words. That would be exempt from the Medicaid 5-year look-back rule. Even if you're already in a nursing home, okay? And have yet to apply for Medicaid, or even if you have applied for Medicaid. You can give $500 a month, in other words, up to $6,000 a year. The reason I don't like to say that is this. What you can't do is say, I'm giving $6,000 on December 31, and I'm going to give another $6,000 on January 1. Understand where I'm coming from? It's two years, right? In 24 hours. No, that's part of the 5-year look back. It's not $6,000 in 1 year. It's no more than $500 per month. If it's $501, a penalty will apply to that gift. If you apply for Medicaid within 5 years. So that's a Pennsylvania-only rule. New Jersey does not have the equivalent. And you're right. Why is it done? It's done, as you indicated, the purpose of that $500 exemption per month, so it covers ATM transactions, cash transactions, birthday gifts, anniversary gifts, holiday gifts, unexplained cash transactions. It's not a windfall to anyone. It's just so you don't have to look at every single transaction every time you go to the ATM. Okay?
That's interesting. So, in other words, if you take money out of ATM for yourself and just money, pocket money for this, that, and the other, is that something you're looking at too?
Well, it
Do
depends.
you know what I'm saying? Like, for example, you go to the market, you may use a card, you go to the gas station, you may use a card, but you still like to have some cash in your pocket for other incidentals.
The answer, the comment is, well, does the Medicaid agency look at 5 years worth of records, and within that, do they look at every ATM transaction of $100? No. But if you're taking $100 out a day, for every day you give $100, you take out $100, they may say something's up. Or if you're taking $1,000 out every week, yeah, you probably have to explain what you did with that cash. Or you have checks payable to cash. Yeah, you probably have to explain what you did with that money. So, but smaller transactions, not necessarily. Okay, so it's important. And again, I can't emphasize this enough. We are a creature of being human. We don't think about the ramifications of our financial decisions necessarily. What's going to happen out 50, 60 months. You can't live like that. We're human. You're not gonna, I guess there's some people who do. I certainly don't. But if you don't want to commingle funds between parent and child, for example, especially if someone's been diagnosed with some form of dementia as well. So you do want to keep track of those expenses. Okay. So. And certainly once a dementia diagnosis, you want to separate assets. Once in a while, I'll have, I don't know why, but every once in a while I'll get the children, they're in their 50s, 60s, and they have a parent in their 80s or 90s. But they still have bank accounts to get. I'm not talking about for convenience purposes. They have $500,000 of stock that they own jointly. Because mom purchased it for them when they were children, and they never changed the account. Right? I don't know why people do that, but some people I see do that. Maybe it's just laziness, and they don't see any reason to. So that's a problem. Because then you have to prove whose money it is. It's not that simple. Is 50% the parents, or it's not the parents? So it's not simple to prove. So, but there are issues that occur, but life isn't perfect. So, but you want to try to control what as best as possible what the situation is. So, any other questions? And I'll just have yes.
If you have an IRA in both their names, like if you have an IRA in your husband and myself, in our names, does that get split, or how does that work when you're spending down? You said the wife can keep just what's in her name? Or?
Well, for Medicaid purposes is the question, what can spouses keep? I'm going to say this one more time, and I'm not going to say it again. In a spousal case, the healthy spouse can keep $126,000. The primary residence is exempt, not a second home, one car, and the healthy spouse's retirement account. Everything, and the Medicaid spouse can keep either $2,400 or up to $8,000. Everything else must be spent down to zero. So if the Medicaid spouse has a $150,000 retirement account, that has to be part of the $126,000 that the healthy spouse can keep. Got it? So, so that means that retirement account to qualify for Medicaid needs to be liquidated if it's not the healthy spouse's account. Are you with me?
Yes.
Okay. I know it's confusing stuff. So I've been doing this for 20 years, and I could say it in my sleep. So, but these rules are confusing. And when you think you got it, you know what's going to happen? They change the rules on you. Of course. So just when you got it, then they change them. Question?
Apologies if you addressed this in the VA part. So if someone is
that count toward those?
The question is about veterans benefits, specifically the aid and attendance. If you're getting the $1,200 as a widowed spouse through the VA benefit, does that count for the $2,313 income cap? That is such a great technical question that I don't have time to answer. But in short, it depends. That's a lawyerly response. Generally, the answer at the state Medicaid agency level will be yes. That's your $1,200 is part of the 2,313. My argument, from based upon my knowledge of federal law and specifically VA and Medicaid law, is it should not. And the reason it should not is a little complicated, but you have to have an advocate. And so that's kind of be my closing. But you need an advocate to argue that VA benefit should not count to the Medicaid 2313 income cap if all of the VA income that comes in every month is used for medical expense purposes, home care, assisted living, adult day, etc. So that's the legal argument to make, based upon case law, by the way. But sometimes caseworkers don't believe that, county caseworkers. But that's an excellent question, but the law is not always followed. Okay? Yes.
Our mom has IRA still. How is that treated as an asset? How do we look at that?
For a single individual, the IRA is a countable asset for Medicaid eligibility purposes. Because there are no spousal protections. Okay? That's the reason.
She's a widow, but so it still counts.
100% of the assets, excluding the home and one car, count for eligibility for Medicaid for a single individual. Okay? Now, there is a minor exception to that. And this applies to, I don't want to get too technical. Let's talk about, once in a while we'll get this. And, back to younger couples. Let's assume you're a couple, there's 55, late 50s, 60 years old. The healthy spouse is still working. And this could apply, in PA it's not a major issue because it's an exempt asset, but it's more of an issue in New Jersey. So 50% of our practice is New Jersey based. So in New Jersey, any New Jersey folks here? Anyone want to move to New Jersey? I live in New Jersey. It's not that bad, really. Just high taxes, right? So, but we're fun people. But it's if you're working full time and you have a retirement account, there's a strong argument to make that even New Jersey, the healthy spouse's retirement account is an exempt asset because you're not able to liquidate because you're working full time. And under what's called ERISA laws, the retirement account is exempt because you can't take money out unless you take a loan on the policy. The government, meaning Medicaid office, could not require you to take a loan on your money for any reason, whether it's your 401k or whether it's to take a loan or a second mortgage out on your home. So if the only way you can access any account is by taking a loan on the money, so therefore the cash is inaccessible, it's an exempt asset. Okay? Question?
Getting out of Medicaid, since I will never apply for that, and qualify. I am trying to get my husband to stay in the house as long as I can. And then maybe move him into an institution. What I find out is most of these institutions don't give priority to anyone who actually needs memory care for personal care unless you already entered as an independent living candidate. Are there advocates? In here you have a good list of all the different homes. Are there special places one should be looking at, or certain institutions that are more lenient towards that you have your opinion on that?
You ask a question I cannot directly answer, mainly because of time constraints, but it's an open-ended question that really has no specific answers. But what I will tell you is this. money talks. Long-term care is big business. So, and that's what I said was I used the word advocate. Most people get lost in the system. The issue is not getting the greatest will. The issue about all the issues we just discussed almost over the past 2 hours is about navigation. And I'll wait for the So, and to explore your options, whether it's related to financial, whether it's related to future housing options, be it a continuing care retirement community, an independent living, assisted living, nursing home, or staying at home. The resources, Medicare, Medicaid, VA, your own money, tax issues. So the main focus is you need someone to help navigate all of those issues. So we do all of that within the confines of our office, including looking at different housing options via our elder care coordinators. And Allison and her team do some of that here as well. So there are many places to turn to. Some of the investigation you would need to do on your own, especially if you have the wherewithal to do so. But you need to plan accordingly. That's the bottom line. And it's not easy. And it's not always pleasant to think about these things. But what I can tell you and I can leave you with is that whatever the situation that you face going forward, if you have a plan in place, subject to revision of course, you're going to feel reassured and better about yourself. And it's much more than just getting your wills, powers of attorney updated. It's understanding what the financial outlook will be, what services are available that I'll pay for that. And once you get that in place, then you'll feel a little better about yourself. And then you could be left with just being where we started this evening, being there for your loved one and providing the care that he or she needs and he or she arguably deserves.